Hello, everybody, and welcome to the first episode of The Third Side, which is a podcast dedicated to mediation and all issues relating to mediation. And what we will do in this podcast series is to take a particular topic as a sort of primary focus of the podcast and then raise that with a guest who's an experienced and senior member within the field of mediation and discuss that topic with that particular person. And to kick that off, I'm very pleased to welcome Dr. Herman Edeling, a very well-known figure in medico-legal circles. But as many of you, I'm sure, will know, is Dr. Edeling has taken an active role and interest in mediation over the last few years and has had a tremendous input within South Africa to get mediation to the point that it is at the moment, which is a very exciting jump-off point. Before I hand over to Dr. Edeling to introduce himself, I'd just like to introduce the topic, which we believe is of particular importance. And we will see during the course of the evening that there really are some deep themes that run through this topic and which could have an instrumental effect on how successful or otherwise mediation is in South Africa. And that topic is the Mediator's report and what should be, in particular, what should be contained in the Mediator's report, with particular reference to the balance between the traditional mediation approach of respect for confidentiality and the concept of efficacy. In other words, getting mediations properly attended in a bona fide spirit by all the parties. And in particular, this topic arises from certain provisions within the Gauteng Protocol, which require mediators to make certain remarks about whether there's been bona fide participation within that particular mediation. So that's just the topic in general. I'd just like to welcome at this point Dr. Edeling. Herman, great to see you again.
Thank you, Ian. Thank you very much for inviting me. And hello, Sheena. Lovely to talk to two of you.
All right, and then just to start off, I'm going to just immediately then ask Sheena to introduce the topic and just to give us some a legal context and orientation and root this conversation in principle first and foremost, and then let's develop some of the themes that arise out of that. Sheena?
Thank you very much. So also just to our viewers to let them know that this podcast is hosted by Advocate Ian Dutton and myself, Sheena Jonker. And we are going to be having interesting and informative guests like Dr. Edeling into the future. So we're very, very honored to have him. So I wanted to ground the conversation in the without prejudice privilege or the without prejudice doctrine. So in our common law, we have the without prejudice doctrine or privilege that means that at common law, evidence of any admission made in an honest attempt to reach settlement in a dispute cannot be disclosed in evidence without the consent of both parties. So already there at common law, you can see that there's an element of good faith. So only good faith utterances are protected. Only admissions, oral or written, made in good faith to settle disputes in a situation where agreement is not reached are protected. So the other aspect of that is that when agreement is reached through a without prejudice negotiation, then the aspects of the agreement reached can be pleaded and also proved in order to conserve the idea that we should be making agreements enforceable in our law. So the policy is that the law should promote pursuit of settlement between parties without concern for any adverse consequences in litigation. And it's important to note that the without prejudice doctrine, we submit that it does not need to be expressed. Well, it doesn't need to be expressed at common law. So you don't have to say that these negotiations are without prejudice in order for them to be without prejudice. they are protected by the without prejudice doctrine the minute it is a good faith attempt negotiation in order to get to an agreement. So whether it is expressed that the proceedings are without prejudice or not, it would seem that this without prejudice doctrine is going to apply to most mediations. And I say most mediations because there are limitations to the doctrine. So where negotiations are successful in reaching agreements, then evidence of statements made is subsequently admissible, and that is to support the policy in our law that the law should promote the enforceability of agreements reached. So a settlement resulting from without prejudice negotiations can then be pleaded and proved to enforce its terms. So I just want to list a few limitations to the without prejudice privilege, and then an interesting one that applies specifically to mediation. So first of all, a statement that is made in circumstances that cannot be objectively considered part of the negotiations for settlement or reasonably incidental thereto is one of the limitations. A second one is statements that are part of settlement negotiations but are unqualified admissions concerning objective facts are not necessarily protected by without prejudice doctrine. The statement is not concerned with the same subject matter as the negotiations. That's not protected. A party engages in conduct which is misleading or deceptive or contrary to trade practices or fair trading legislation and in an action for breach of the legislation. Where statements or where there are communications which contain an offer and acceptance which actually constitutes a contract, those are obviously not protected. And communications which constitute or disclose criminal conduct. And then finally, communications, the disclosure of which will prevent a party from misleading the court. So there might those are not necessarily protected by this privilege. So the golden thread is that it is good faith statements made in pursuit of an agreement or with a good faith attempt to settle a dispute. Those are protected, and we'll talk about when there's an element of bad faith, and we'll talk about that as a limitation on this. And then also communications which constitute delictual conduct. So the parties can't go around calling each other names in the mediation and expect that to be protected, or saying defamatory stuff and stuff that violates the dignity of the other party. Now, some mediator standards do not inhibit mediators from giving evidence under legal compulsion, and specify that if a mediator is subpoenaed or otherwise required to testify about a mediation in court proceedings, he or she must inform the parties accordingly. Most of the mediation houses in South Africa standards promote the idea that the mediator should, by agreement, not be capable of being subpoenaed to give evidence in court. However, there are always going to be limitations to that. And I suppose the overarching interests of justice would constitute a very, very general limitation that could be argued in cases where one of the other parties feels that that something of that needs to be furthered or explored or whatever it might be. Another potential limitation on the confidentiality principle is found in those situations where mediators are required to report on aspects of mediation to courts tribunals or agency supervisors. Now, I'm reading here from a textbook by Buell and Rycroft, which is Mediation Principles, Process, and Practice. So they refer to case law. I'll put the sources and the reference into the notes. I'll ask Che to put that into the notes so people can read further on this. But I think that the directive actually falls into that category, where the directive has located mediation in a space where there are certain aspects of the mediation that the mediators are required to report on. And as I understand it, at common law, this is a permissible limitation. Another example of a limitation might be that the parties themselves agree that certain aspects of the process are not covered by the without prejudice privilege. And so, but in most agreements, we are saying that the parties agree together with the mediator that this process is entirely confidential and it's entirely without prejudice, and that's expressed in the agreements. It's expressed in the ground rules. So what leads us to this discussion, this very important discussion, is the discomfort that is widespread right now within the mediation industry and across the legal profession, with the idea that certain aspects of the mediation are to be reported on by the mediator. So we want to balance the reputation of mediation with, as Ian says, efficacy in these processes. I think I'll leave it there for now, Ian, and maybe you can expand on what you want to there.
Yeah. All right. Thank you very much for that, Sheena. And, you know, what I really appreciate about that is that it does, as I say, locate this conversation within a specific legal context and grounds it within principle. So we're not just having a loose conversation. I think it's quite clear from what you've said that what strikes me, I think, most is that it's clear that this concept of without prejudice or confidentiality, however you delineate that, is subject to restriction in given circumstances. And I agree with your characterization. It does seem as though, and I agree with the points that you've made insofar as your description of the common law is concerned. So to me, that's the important point. Some of those categories, you know, I would need to think through a bit more carefully, and others don't seem to be relevant to mediation. But the one that you identified certainly does seem very relevant. So that's my comment in what you've said. So I think the important point to me, the takeaway point is, well, confidentiality in South African law is well recognized that it and without the concept of without prejudice can, within certain circumstances, be limited. And the question is, what are those circumstances within this particular context, and particularly within the context of writing the expert report? And I'd like to unpack this evening. Now, just turning to Herman's input here. Herman, I know that you and I have had private discussions about this very concept. You know, I know that you share my view that this is potentially a very important aspect of how this mediation initiative unfolds. But, you know, I think let's hear your views on the topic, and, you know, obviously feel free to comment on the introduction which Sheena has given us. But why don't you share your insights on this view for us, Herman?
Okay, with great pleasure. And thank you very much for that, Sheena. Now, let me start off by saying this. It's important to understand that I'm a non-lawyer, but I am a mediator. So I was listening very carefully to the points you made without wearing a legal hat. And I must say, to the extent that I understand or understood, and I did not fully understand every exception you gave, but to the extent that I could understand, they all made sense to me. That it seemed that is the right and proper way that it should be. Okay? But I was also very pleased as I was listening to that as a mediator, I don't have to worry at all really about those things, because I do not believe, unless I'm called by a court to testify, but I would have no interest in going and sharing information that was shared confidentially in the mediation. So whether a thing can or can't or should or shouldn't be expressed outside the mediation, the simplest for me as a mediator is to say it's confidential, that's that. And,
Yes.
and it also appears to me that the interested party who would want to disclose something in court, and under one of those exceptions, would be the aggrieved party, who can then go and argue that in court. And that aggrieved party who does the argument will be a lawyer, and that lawyer must understand the law, which includes all of these exceptions to the confidentiality doctrine. So what I'm really saying in a nutshell, as much as I find it interesting, I find it's not compelling for me as a mediator to try and remember those things, because I have to remember them.
Yes.
I have to remember as a mediator, I don't talk out about what was said.
Absolutely.
Now, that is the first point I want to make. But the second point, I think, is far more relevant to the current issue. And in order to state this clearly, I need to differentiate between process and content in a mediation. Now, by content, I mean the issues in dispute, I mean the evidence, I mean the arguments, the position of the parties, concessions that are made, explorations that are done during negotiations. All of that is content. But the process is, you know very well as mediators what the process means. It is the way the mediator conducts the mediation. So let's call it the rules of mediation. Okay? Now, if I were to conduct a mediation between two neighbors who are arguing about a tree that is one's bothering the other one, and there's nobody else involved in this dispute, the two neighbors come to me and ask me to mediate. I'm not going to have any reason to tell anybody outside the three of us anything about the mediation, because it's a private matter. And they both came voluntarily and asked me to mediate. And that is essentially what mediation is about. Both parties freely and voluntarily agree to mediate, and the mediator agrees to be impartial and independent, and to not make decisions, but to assist them and to keep quiet about it. Unless, of course, there's an agreement, and that agreement becomes a written contract, then that can go out and be disclosed to other people. And that is what all the mediators, the mediation trainers, the mediation houses that I've heard speaking about this have spoken about protecting the honor and the integrity of mediation in that sense. But now, in the current circumstance in Gauteng, there's a new dimension which has been introduced. And that dimension is the Gauteng High Court's mediation directive and protocol.
Yeah.
Now, that whole protocol, okay, so essentially the directive is about getting court dates and losing court dates, etc. But the part of it that affects the conduct of the mediator and the mediation is all contained in the protocol. Now, that protocol is nothing other than a process prescription. Everything in the protocol prescribes, under the authority of the court, how the process should be conducted by the mediator and by the parties. Now, it cannot be that the process is confidential, because the process is already enforced by an outside authority, which is the court. And I think that's why it is crucial for the mediators and the parties to think clearly and properly understand what are process aspects and what are content aspects. Now, what brings it in the current context far more sharply into the spotlight is the requirement for the mediator to write a mediator's report.
Yeah.
And in that mediator's report, it's not a very
Sorry,
long
can
report.
can I just jump in, Herman? And Che, I think we might just have to edit this next section out. But I actually have that protocol on my computer, and I was about to share that section, Herman. So unless you wanted to share it, but I don't have sharing facilities. That's the one thing. The other thing
No,
is that we've got.
I can make you a co-host,
Okay.
Ian.
All right, great.
Okay.
Thanks, Sheena. Just the other thing, just quickly, is that we've got a hell of a southwesterly blowing down the coast, and one of my windows is open, and my blinds are rattling against the window. So let me just try and lift those blinds so they don't make a noise in the background. Just give me a second or
Okay.
two.
I can't hear anything from here, Ian.
I've been muting it, Sheena. It's sort of rising and falling. So when
Oh,
it's getting
yeah.
bad,
I'm
I'm muting
wondering
it.
why
Yeah.
you're muted.
Yeah.
Okay,
Yeah.
Can I
Che will
suggest,
edit this all out.
can I suggest the following? Let me make my point, and then we
Yeah.
can go in the directive and in the
Okay,
mediator.
that's fine.
What I'm talking about.
That's fine. However you want to do it, but as long as I've got access to that sharing.
Yeah.
Okay, just
Yeah,
give me a
I've made
second.
you co-host, yeah.
Thanks a lot.
Okay. All right. So, Sheena and Ian, the mediator's report requires the mediator to report to the court.
Yes,
And most of the report is not controversial. It's the names of the parties, the case number,
absolutely.
place where the mediation occurred, the date, it's all of that. It's just administrative detail, which is not
Yes.
controversial. The problem comes in about this whole issue in the part of the mediator's report that asks the mediator to comment yes or no on the following 6 questions. The one is, was there a signed agreement to mediate? The second is, were both parties in attendance? The third is, were both parties prepared? Now, there's a problem because if
That
a party
starts
is not
veering
prepared,
into, yeah.
and the mediator says the one party was prepared, the other one wasn't, or both were not properly prepared, the mediator is expected by the court to express a judgment or discretion on whether the party was adequately prepared. Okay? But now, in answering that question, the mediator is not being asked to disclose the content of the mediation, or the facts in the matter, or any concessions that were made, but it is a process issue of preparation. And I'm not going to express an opinion as to whether that's a good thing or a bad thing, because this is a protocol put out by the High Court.
Yeah.
And as a mediator, I am subject to the protocol put out by the court.
Yeah.
So I'm pointing out that to act as a mediator in Gauteng court annexed mediations, it is necessary to act in accordance with the protocol.
Yeah. So can I just make one quick point there while you're on that point, because it's a very important point. When commenting on the preparedness or the unpreparedness of one of the parties, I want to caution our mediators specifically to be very cautious around that, because that can live in the mind of the mediator, making it a very subjective thing. That guy didn't look prepared or whatever. And I would caution my mediators to limit commentary on that to where a legal representative shows up and says, I haven't been briefed properly, or I haven't been given information, or anything like that. But if you are making a comment on someone that's like rifling through their papers and they look unprepared to you, it becomes very subjective. Do you know what I'm saying? So when commenting on that, when ticking that box, try to limit it to overt, this party said to me they got the papers this morning and hadn't had a chance to read through them, or I haven't been given the papers yet, or we'll go into the mandate situation, but I mean, equally, I don't have a mandate or whatever it is. So this is a very important point, and I want to be developing this with our mediators and kind of like workshopping how to actually do these reports in a way that does preserve the reputation of mediation, but also does support efficacy, as you and I spoke about the other day, Ian, because we know that one of the parties to these mediations is a very big organization that I don't know if you want to expand on that at all, but
Well, I mean, I could say that the Road
yeah.
Accident Fund has repeatedly by the courts been
Yes.
described as a serial delinquent
Yes.
participant in litigation.
Absolutely.
That's a matter of public record. That the judges have been making that type of comment for more than a decade.
Yes.
And I think that this point does obviously have to be made that it seems to me that the reason for paragraph 7.1.3.5 being there is to militate against parties not attending mediation bona fide. In other words, just simply coming unprepared, coming without a mandate. There are a number of specific examples referred to in that sub-paragraph. But what we talk about, the mischief which is being addressed, is a lack of bona fides on the part of one party in participating in mediation. I think that the related important point, Sheena, is, I come from a background of litigating personal injury matters against the Road Accident Fund. I don't deal with it on a daily basis as attorneys do. I deal with it once it really gets to court. But the levels of frustration with the Road Accident Fund not following simple procedures relating to trial readiness is very high. And one can't speak specifically for the judges, but looking at the intention of the sub paragraph, it seems pretty clear that it's to weed out that type of dilatory, foot dragging type approach, so that now the mediation becomes an impediment to a resolution of the dispute, just another obstacle that attorneys have to get over.
Yes, and can we just reiterate
just to finish the point, Sheena. And it seems to me that needs to be in some, however this is dealt with eventually, and I will make a point later, commenting on where I would imagine this will go, but however this is dealt with eventually, that particular concern would have to be addressed. Otherwise, we sit with long queues waiting for mediation. You get to mediation and then it's unsuccessful. You just have to wait for a trial date. So it extends the process. It doesn't shorten it.
But I just want to reiterate on your point there that at common law, bad faith is not protected by the without prejudice doctrine. And I think we all need to bring our attention to that and our awareness to that. The discussion I want to have with our mediators is what actually constitutes bad faith, and also, set up guardrails on commentary on bad faith, not just living subjectively in the mind of the mediator. They didn't like this person or that person, so they had a bad faith energy about them. That's not enough. Do you know what I'm saying? It's like overt acts of bad faith. But Herman was going through the list of 6. So let's proceed with that. So that was on the issue of preparation or lack of preparation. So now we start veering into territory that looks like the actual substance of the mediation rather than just procedure. So
okay. So Sheena, yes, I'd like to continue to comment. So it's interesting that the moment I got onto the issue number 71353, both parties prepared, that gave rise to such an avalanche of discussion between yourself and Ian. So it's obviously an important issue.
Definitely.
And a lot of the things that you and Ian said, I agree with, but I would like to make some comments about that. Of those 6 sub-paragraphs of 7135, 3 are not potentially contentious and 3 are potentially contentious. So the non-contentious ones, agreement to mediate signed, both parties in attendance, and no logistical issues experienced.
Agreed, non-contentious.
The professional integrity of anybody. But the other 3 are all contentious or potentially contentious. First was what you said, both parties prepared. The second, a proper mandate to mediate and or authority to settle. And
Yes.
the most potentially contentious one, the parties participated in good faith.
Yeah.
And
Yeah.
actually, all of that are different ways of saying almost the same thing.
Yes.
Okay. But now the mediator must express an opinion on all three. Now, instead of dealing with them individually, I'd like to deal with them collectively and agree with what you said about subjective interpretation. Now, I totally
just before you get to that, I just want to point out, and Ian can pull up the directive. In the box where it says bona fide or not bona fide, it says yes, no, or not applicable.
Yeah.
And in the directive, in one of the versions, and we can check on the latest version, it says the mediator may comment on the bona fides of the parties. So it's not mandatory. So that box ticking can be used within the discretion of the mediator. So let's just, I just wanted to point that out and see if if I remember that correctly. Sorry, carry on, Herman.
Okay, so now I'd like to get onto the subjective and objective element. Okay, and totally agree with and support what you said, Sheena. No mediator should express any adverse opinion on any of those three if it is subjective. And the mediator should understand their own mind well enough to know what in their mind is subjective and what is objective. Because if a mediator expresses a subjective opinion on any of those, it will be very wrong and it will be bad for the mediator, and I believe also for the reputation of mediation.
Yeah.
So to me, one of the major ethical pillars of mediation that all mediators should hold themselves to is that they should completely avoid expressing any subjective opinions.
Yeah.
The various examples you gave about preparedness, which would be subjective, my view is simply don't do that at all. However, one cannot avoid those three questions altogether.
Yeah.
And so my view is one should only express an opinion if you are confident that your opinion, which is an adverse opinion, is well-founded in fact and reason, and it can be objectively proven.
Yeah.
And if it is not well-founded in fact and reason and objectivity, then don't express it.
Yeah.
And if it is necessary to express an adverse opinion in any one of those three, then it is incumbent on the mediator in the section below that, which says additional comments, to put there, in however long you need to write, but to put there the reasons for your decision. And those reasons have to be objective, and the reasons have to be persuasive. And if you can't write objective, factual, persuasive reasons, then don't make a decision. Don't make an opinion.
So again, the example there on preparedness is one of the parties literally told you they're not prepared. One of the parties literally told you they haven't been briefed, or they were briefed an hour before and they have not had the chance to read through everything.
I can give you other examples.
Yeah.
Let me give you another example. And the example I'm giving you is what comes out of our SAMLA RAF mediation pilot project experience.
Yeah.
Okay. So in that, it is necessary for the process to either agree or disagree on the outcome diagnosis of the injuries. In other words, what is the nature of the permanent impairment?
Yeah.
So the person has got permanent back pain. Yes, no, it's bad, mild, severe, it's fabricated. There has to be an agreement about the permanent back pain or the chronic back pain. If the thing is loss of a toe, if it's 2 or 3 toes, there's got to be an agreement on how many toes are lost. Okay?
Right.
On each of those elements of the outcome impairment, so the extent to which the person's function as a human being is limited by the consequences of the injuries. On each of those, when the mediator gets to that point and asks the one party, what are your submissions about this point? and the party clearly makes the submissions. And if the mediator says, well, where do you get that from? And they say, well, this is from the occupational therapy report, see there on page so-and-so, and then, or from the orthopedic surgeon's report, and that's where it is, then that's fine. So they have shown why they say that that is a permanent impairment. And then if I ask the other side, and they say, no, they deny that. And then the mediator asks the person of the other side, why do you deny it? No, that we don't believe that. Okay, why don't you believe it? No, because that orthopedic surgeon is a crook. Or no, I don't know why, but I just know we don't accept that.
Okay.
Now, in that case, where the mediator tries to extract reasons out of a party for disagreement, and the party doesn't give reasons, either stays silent or says they don't know or makes evasive arguments, the mediator can see this person is not prepared. They deny a thing, but they don't know why they're denying it.
Got it, yeah.
And I think in that circumstance, the mediator should say clearly that party was not prepared. But then the mediator should write in the comment section what happened, what questions were asked, and what kind of answers were given to say what made the mediator believe that the party was not prepared.
Herman,
But
can I just come in on this now?
But that would only be relevant if an agreement is not reached.
Yeah.
Because if the party isn't prepared and doesn't know, but at the end they come to an agreement on money, then all of that falls away and it doesn't have to be reported.
Yeah. But let's hear what Ian has to say about that.
Yeah, what I just wanted to, I think that's useful, Herman, but there are a couple of little red flags that going up for me, and I think we need to talk about this with quite close reference to the protocol, because I agree with the point generally, but let's have a look at the specifics, because the devil's often in the detail. So we've had a look at the body of the protocol a few minutes ago, where it set out the various considerations, and you took us through those 6, Herman. If we have a look now at the prescribed, the template for the report, you'll see that there's reference in this section to where there's a partial settlement. You need to set out various facts, and then feedback on administrative process efficiency and suggestions for improvement. All right, and then you've got protocol compliance. Now, as I see this, if we look at this mediator's report, we've got some sort of more administrative type information in the beginning. Then we've got a section on partial settlement, and then a section on without prejudice offer or tender. And then we get to this feedback on administrative process efficiency and suggestions for improvement. Those all seem to be separate to the protocol compliance, which looks to me like a standalone section. And interestingly, what the template provides is these 3 answers to each subsection, which corresponds to the body of the protocol. And the first one is simply agreement to mediate signed. And again, that's a straightforward, it's either signed or it's not. I don't think there's much controversy there. Both parties in attendance, again, both parties prepared. Now that becomes controversial. No logistical issues experienced. That is maybe a little bit more, let's say, objective, but a little easier to answer. Representatives in attendance evidenced proper mandate to mediate and or authority to settle. That's, to me, that's not that difficult to deal with. Either they had a proper mandate or they didn't. And there's the additional comments below, which you've referred to, Herman, so you can always elaborate on that. The parties participated in good faith. To me, that is potentially problematic. And so really, breaking that down further to what you said, Herman, is both parties prepared and both parties participated in good faith. Now, Herman, remember the training that we did with conflict dynamics? There was a comment that all the mediator needed to do was really just tick these boxes. So if both parties were not prepared in the mediator's view, the suggestion was that you just tick the no box. And same with 6, both parties participated in good faith, just say no. and that's it. There's the mediator must go no further. You know, I have some misgivings about whether that's correct. And the reason I say that is because it seems to me that going back to my earlier comment, the reason for the existence of these provisions is to enable a judge ultimately to be able to decide whether there's been proper good faith participation in the mediation. There may well be an adverse costs order associated with that or some other sanction. And my view, you know, it is an early days view, but I have the view that it is incumbent on mediators to comply with these provisions. And if there hasn't been good faith or the parties haven't been prepared, you are required, if you're doing this type of work, to complete those portions of the protocol. And I would just finish on this point, that this debate about whether confidentiality is good or bad, and whether these principles of mediation, long established hallowed principles of mediation, are being complied with or not, is to an extent redundant, because this protocol requires mediators to answer those questions. And my view on a plain reading of this template report is that you are required, if you're of the view that both parties did not participate in good faith, you're required to tick that box no, and then to make additional comments. You must give some sort of indication as to why, because it doesn't help the judge just to be given a straight no and with no motivation. So that's my initial view, and I'm happy to be, you know, to reform that view. But reading the template, that's my view of the requirements in terms of the protocol. Whether that's right or not is this possibly the subject of, that's a different question, and that's a more overarching question. But that's as I read the provisions of the protocol.
And I think, Ian, just to again come back to what you said in the beginning, is balancing the reputation of mediation with efficacy. And this directive is specifically set up to ensure that there is effectiveness in these types of mediation. So it can't just be a box ticking exercise. So the fact that parties know that their preparation conduct is going to be reported on, or potentially be reported on, their good or bad faith conduct. And just going back to what Judge Davis said in Johannesburg at the end of, I think it was June or whatever it was, and he gave the example of someone pitching up to mediation without a mandate. And he said, well, that's open and shut bad faith. You don't get more bad faith than that. So you're coming to the process to tick the box, to hopefully just get your trial date. You're not there in good faith to actually participate in the mediation if you are not prepared and or you don't have a mandate. So
just complete there, Sheena.
So I think that part of the way the directive is structured is to, as you said, support efficacy in mediation, so that it can't just be used as a box ticking exercise, so that parties can say, well, we've been, now can we have our court date? Because
no, I agree with that.
Because this is an earnest attempt to try and get as many matters resolved as possible in the busiest courts in the continent, where there's just there's no hope of clearing up these roles in any other way.
No, I agree, and I just want to make just to follow through on what I've said. So I just want to, in the context of what I've said, just support a very important point that Herman made. And that is this point about objectivity. You know, my view is this, that because you are required to tick those boxes, and if you put a yes, I don't think there's be unlikely you'd need to make a comment. So it's really where one or more of those boxes is ticked no, that I think it's very important that then those objective criteria. So for instance, a person just simply didn't have a mandate. I think that should be set out, and I think some detail should be given about that. But you need to balance that and try to root that within objective facts, not, and
Yes.
it actually goes to the point that you made as well, Sheena, not just your subjective assessment of what happened. So I would, as mediator, and we will learn as we go forward, but my starting approach here would be that I'd err on the side of conservatism insofar as the comments that I made, but I would try to be objective and fair-minded about each of those answers. But
Yeah.
I would regard it as my duty to say no if I didn't regard that as having been complied with, and I would also regard it as my duty to make the additional comments, but to try to keep them to objectively verifiable facts and not get into areas of dispute through sort of subjective assessment. That would be my approach.
Agreed. Agreed.
Yeah. Thank you for those comments. I was a little bit disappointed because from the introduction to your comments, I got the idea you were going to argue with me and point out things.
Yeah,
that
there
I
were
was
red
wrong.
flag comments.
And
Yeah.
then I
Yeah.
listened, and it sounded as if you agreed with everything I was saying.
No,
I was also a bit disappointed. I wanted a bit of beef here.
I'm sorry.
Yeah.
I'm sorry to disappoint everybody, but the red
Okay.
flags that I was referring to were the red flags actually in alignment with your point. Disappointingly,
Okay,
that
so-
if people shouldn't stray into subjective assessments. In fact, I managed
Okay.
to agree with both of you at the same time. Really, you know that's a
Okay, so well, Ian, but that's good. But let me emphasize this: we are not here to be an echo chamber, nor to win an argument. We are here to discuss issues of crucial importance to mediation and to the interests of mediators and parties and the courts.
Yes,
So
absolutely.
it doesn't matter if we agree or disagree with each other. What matters is that we think about and motivate the issues we are saying.
No,
So-
Also figure
completely
out
agree.
and figure out the
sorry,
best way to work
Yeah.
within this directive.
And what I would add to that is I'm also quite happy, and I think the right approach is that if it's on some subsequent occasion, somebody who has a different view comes and expresses that view, I'm very happy to modify my view. And
Yes.
and this is an important point. You know, no one at this stage has the absolute answers. And this is a point that I do want to make. You know, just through my experience in the courts for the last 30 years, sometimes you tend to think that there's some absolute abstract answer to these questions. Often these complex sort of Gordian knot type difficult theoretical questions, the way they get resolved through the court process is over a period of time. The judges deal with specific cases on the specific facts of that case, and the principles start emerging over a period of time. You start seeing a cluster of cases, and you start seeing principles being developed with actual facts and actual circumstances. And I have a very strong feeling that that's what will happen here. But it's in order to inform, then really what we're doing tonight is simply contributing to the debate, and eventually we'll get guidance from the courts.
I just want to jump in there very quickly and say two things. The first thing is there's a big storm coming, guys, and it looks like lightning. So I think we're going to have to stick to the 7 o'clock stop. The second thing is that that there's a flexibility built into the directive. And there's a reporting process, so all the RMOs have to report to the judge president on a quarterly basis. And the idea, as I understand it, is that we all figure out how best to work with this together. So collaboratively, the legal profession, the emerging profession of mediation, we come together and we have discussions like this, understanding that it's located within a flexibility that is there to make sure that we can give feedback on what's working, what's not working. And I think those reports are part of that, very much a part of that, aside from supporting efficacy in mediation and kind of rooting out bad faith and what do you call it, delinquent behavior in mediation.
Sheena, can I share my screen for a moment?
Yes. Let me make you a co-host.
Okay.
Okay. Perfect.
All right. So what I'm showing you is page 15 of the protocol. See at the bottom is page 15. And the paragraph is 6411. And this actually is the instruction that involves everything we've been talking about. It says the parties shall act in good faith during the mediation process.
Yeah.
The parties shall provide the mediator with all relevant documents and information that may be pertinent to the matter or that the mediator may request. The parties shall participate actively and constructively in mediation sessions, and the parties shall comply with the rules and guidelines established for the mediation process, including any timelines agreed upon. Now, those provisions apply process requirements on the parties, but they also, together with the mediator's report, they apply a duty on the mediator to report if those were not complied with.
Yes. Yeah.
Now, if non-compliance or almost compliance or incomplete compliance did not result in shipwrecking the mediation, and there was a satisfactory conclusion, then it matters not.
Mm.
But if, in the mediator's judgment, the mediation failed because of clear, objective, factual evidence that one or both parties didn't comply with these four provisions, any one of those four provisions, then I feel it is the duty of the mediator to tell that to the court honestly. And I don't see that a mediator would have any interest in disclosing or not disclosing that. But all of those things, in my mind, and I would be happy to discuss it with anybody that disagrees with me, but to me, all of those relate to process and not to content. And the overarching thing to me is here. In this Gauteng High Court annexed mediation process, mediation is being employed by the courts as a tool to reduce load on the courts. That is not the traditional place or role or ethos of mediation. So mediation has to remain true to its heart and its soul and what it is.
Yeah.
But if a mediator agrees to mediate under these provisions, which means subject to these process prescriptions, then the mediator has to fully agree and function according to these prescriptions. And it doesn't help to say, no, but it's not proper in mediation to disclose whether the party was in good faith.
Yeah.
To me, that's not open to the mediator.
It's not. And there are various different forms of mediation where there are lots of different limitations that might be imposed on mediation, either statutorily or by agreement between the parties themselves. So the CCMA is a good example of that, where you don't have the high levels of volition at the CCMA that you have in private mediation. But just to come back to a point that you made, where this particular directive, I think you said something along the lines of it's not within the normal ethos of mediation because of the high degrees of confidentiality, consensuality, volition, and that kind of thing. But remembering that mediation is a powerful form of access to justice, which is a very important thing in a society like ours, where access to justice is a tricky thing. And if we're going to support mediation as a form of access to justice, then we must support attempts by the judiciary to support the efficacy of mediation so that it actually works, that people are committed to make it work. So, for example, our mediation agreements say that this mediation is being mediated within the Gauteng mediation protocol and directive. So there's built-in agreement that the parties know that that this particular mediation is limited in this unique and peculiar way, because this is how the judges have structured it. And we could even go into the fact that at common law, judges have a discretion on how to regulate their own processes. And this is an outpicturing of them regulating their own processes. So, which they're entitled to do, whether it's in litigation or providing a platform.
Just before you answer, we've got 4 minutes left, so let's start wrapping up. I think Herman, if you'd like to make a quick response to what Sheena said, and then I'll wrap up and just have final comments.
Thank you, Sheena. That makes perfect sense. And we have now the duty of preserving mediation, but also properly applying mediation to the Gauteng Court Directive according to it. I want to make one comment that I think we should have made earlier. A mediator shouldn't surprise a party in the mediation report. So if during the course of the mediation, a mediator comes to the conclusion you're not prepared, your settlement authority isn't good enough, you're not in good faith, that should be put to the party. And say, tell the party, I've got to write an opinion in the court. Look what you're doing to me. Can you remedy this? What do you suggest we do now?
Agreed.
Because I'm under this obligation.
Excellent point.
Yeah, very much so. And Herman, just that reminds me very much of a related point, which relates to expert witnesses, that a judge cannot simply criticize an expert witness or his or her report without first giving that witness an opportunity to comment on what the judge is going to say in the judgment. And it actually applies in cross-examination as well. You need to put your case to the witness to allow them to comment. It's a fundamental principle, and I've absolutely no doubt that is absolutely right in law, what you've just said. And it also also passes the common sense test. So, all right, if we can then just start looking at wrapping up. I think that from my point of view, it's been very interesting. But let's Sheena, let's get your final thoughts, and then Herman's final thoughts, and then I'll just end it off.
I think my final thought is that discussions like this are imperative. And this is how we work together to figure out best practice within this accounting directive. So us as an RMO, we need to make sure that our mediators are compliant with the directive. And discussions like this help us to understand at a deeper level what that actually looks like and what it should look like. And as I said, also coming off the basis that this directive has a flexibility built into it, which again also makes these conversations very important, because that's how we evolve into best practice, however that might look within this particular situation.
Thank you, Sheena. Herman, your last thoughts?
Thank you, Ian. Yes, as a mediator functioning under the Gauteng protocol, it's imperative to have it clear in your mind what is process and what is content. And you should also disclose that to the parties in the mediation, that I am under a directive of process and I've got to report to the court on the process, and make sure objectively that you only stick to that.
Yes, thank you very much. Yeah, just one or two last thoughts from my side. Is that I think that it's important to highlight that I'm sure we're all in agreement that the principles of confidentiality and without prejudice are absolutely paramount when it comes to mediation. And nothing we've said this evening should detract from that. The question is clearly within this protocol, there's thoughts from the judiciary as to that there are certain occasions where those principles need to be compromised. The question is, how do mediators actually grapple with that in practice? And I'd just like to echo, Sheena, what you said. These conversations are so valuable and important because, as I said earlier, there are no absolute rules, no absolute answers out there yet. We've got some rules already, but we're all learning, and the process is very much, in an evolutionary phase, as you said. So I think we've got to all keep ourselves informed. This conversation I found very interesting, and I've learned a lot from it.
Me too. Thank you.
Yeah, and to step back from the topic itself and just to look at the process of this particular podcast, this is exactly the type of conversation that we would intend holding to allow mediators to stay informed and, of course, to discuss this in further forums amongst themselves and within their own RMOs. So thank you both for your time. It's been invaluable and fantastic as ever to talk to both of you. Thank you very much.
Thank you,
you.
Ian and Herman. Thank you so much. Look forward to the next one.